Hello again, we're talking about the Bill of Rights, and this is the last of 4 videos devoted specifically to the concept of due process. If you've seen any of the first 3 videos on the 4th, 5th, and 6th Amendments, and you think you have a good handle on the concept of due process, you can skip the next 10 slides or so and maybe the next 6 minutes of this video. It might be helpful to have a copy of the Bill of Rights with you. It might be helpful to have this 23-page packet full of Supreme Court case summaries that you've been provided with. It might be helpful to you to have this one-pager that you've been provided with that lays out the entire concept of due process from beginning to end. It's really good to have that understanding of due process, so you don't just focus on the words due process that happen to be in the Fifth Amendment, and you understand that the concept of due process is scattered across several amendments and other places in the Constitution, and isn't just associated with a trial, but also concepts before and after the trial. And it would also be helpful to have this page of due process related Supreme Court case decisions that you've also been provided with. The phrase due process refers to all of the rights that are due to you. That means you get them. The government is required to respect these rights that are necessary for you during any sort of government process that affects you. Any sort of process means procedures or steps that the government takes when it makes decisions about you. And usually when you're talking about due process, you're talking about the legal or the criminal process. The government is deciding whether or not to lock you up or punish you in some way. So maybe one way to summarize due process is all of the necessary steps that government must take in order to punish someone, or in other words, all of the rights you must receive in order to have a fair trial. For this reason, sometimes your due process rights will also be referred to as the rights of the accused. And as the chart that you've been given tries to illustrate, your rights as an accused person, your rights as a citizen, your due process rights begin well before a trial. They exist before the trial, they exist during the trial, and after the trial. They are referred to in several places in the Constitution and by several amendments in several places in the Bill of Rights. For example, if you refer to the due process rights and related cases handouts you've been given, you'll see that your due process rights restrict the behavior of the government even before you are arrested, because in order to arrest you, the government must have something called probable cause. Probable cause based on evidence it has already gathered. The gathering of that evidence is pretty much the rules for gathering evidence are laid out in the Fourth Amendment, where it says you have freedom from an unreasonable search and seizure. So the government must conduct its searches or seizures of property or evidence in a legal manner consistent with the Fourth Amendment. Those cases off to the right there, don't worry about those. We'll discuss those later in the video. Your due process rights are also in effect after you've been arrested or taken into custody and before your trial begins. For example, in the Constitution itself, it says the government cannot arbitrarily detain you or indefinitely detain you without any specific charge. That's called your privilege of the writ of habeas corpus, and that's in the Constitution itself, Article 1, Section 9. The Fifth Amendment, the Sixth Amendment, the Eighth Amendment all have something to say about your rights and the limitations on the government's power in between being taken into custody and having your trial. Notice a couple cases over there on the right. We'll talk about those in later videos. During your trial, you have additional due process protections. Most of them are found in the Sixth Amendment. You can read them over here or in your handout. But there's a little bit of the Fourth Amendment protecting you during the trial, and a little bit of the Fifth Amendment protecting you during the trial as well. The only case in this video that appears over on the right is Matt versus Ohio. It is not required by the College Board. However, the concept that's associated with Matt versus Ohio, the exclusionary rule, is an important concept, frequently appears on AP exams, and will be discussed in this video. After your trial, your due process rights continue to protect you from government misbehavior, let's say. Most of it is covered by the 8th Amendment, but there's still a little bit of 5th Amendment protecting you there too. There are a couple cases there mentioned that'll come up in the 8th Amendment video. And then just to make sure you get a complete picture of the idea of due process, there are things in the Constitution and in the 5th Amendment that govern government behavior kind of completely outside the legal system. We call those extrajudicial prohibitions. You've already learned that the government cannot just pass a law declaring you to be guilty. That's a bill of attainder. The government cannot pass a law that says what you've done that was legal in the past is now illegal and you can be punished for. And then there's another little bit of the 5th Amendment that is helpful also. So as you can see, different amendments kick in at different points in the process. The concept of due process is scattered all over the Constitution and the Bill of Rights. So now let's get on with the rest of the video.
Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted.
Here are some of the words that should be focused on in order to understand the 8th Amendment. First of all, notice the word excessive. It's a very vague, undefined, unspecific term. So there are going to have to be court decisions interpreting what that word means in relation to a lot of the other words that come up in the 8th Amendment. The word bail. The word bail is not a vocabulary word you have to know for the AP exam, to my knowledge. However, it is so frequently misunderstood by students that I do want to take a moment to explain it. You all see on TV or in movies or whatever that if you get arrested, somebody has to come down to the jail and post bail and get you out, or just bail you out. Usually involves an amount of money, usually more than you would typically have on your person, which is why someone has to come do it for you. But frequently misunderstood is the purpose of that. So you've been accused of something, so you get a trial. Well, nobody wants to go to jail, so nobody wants to go to the trial, but you also don't want to stay in jail until your trial. So an option that makes it so you can get out of jail until your trial is to post bail. The money that you give to the court to be bailed out is not kept forever by the court. You're not paying money just to get out of jail. It cannot possibly work that way. Otherwise, the government would just go around arresting everybody and make you pay an amount for bail and then just keep your money. Remember that the Due Process Clause of the 5th Amendment says that the government cannot take away your life, liberty, or property without due process. If bail was just money that you have to pay the government to get out of jail because they've arrested you, then the government would be taking away your property without due process. The purpose of the bail money is to make sure you come back for your trial. And if you do come back for your trial, you get the bail money back. That's the way bail works. A fine is just a monetary punishment, meaning you have to pay a certain amount of money instead of going to jail or doing community service. And here's the key phrase that we all know the 8th Amendment by is the prohibition on cruel or unusual punishment. Please notice again that these words are not very well defined. They are very vague. So it has taken a fair amount of court cases to decide what is cruel, what's unusual, what isn't cruel or unusual. Most people agree that it just means you can't be treated inhumanely. You can't be starved and beaten and tortured, electrocuted and stuff like that. And another way of saying it is that the punishment has to be proportional to the crime. So a cruel or unusual punishment could be, you're fined $1 million for jaywalking or something. If it's a relatively small scale crime, the punishment has to kind of fit the crime. The only crime for which we, in America, as a society, in modern times, permits the death penalty to be imposed is murder. These two cases are in your packet of cases that you've been provided. They are not required by the College Board for the AP exam. However, I thought you might find them interesting. Back in the 70s, a case reached the Supreme Court called Furman versus Georgia. And it was discovered that the death penalty was being handed out by juries in Georgia against African Americans way more than against white people. And the Supreme Court found that the actual procedures, the involvement of the jury, various aspects of the sentencing procedures in Georgia, they found them to be arbitrary and discriminatory, and therefore halted capital punishment or the death penalty in America based on that unfairness. Now, this case could also show up in a question about the Equal Protection Clause of the 14th Amendment, but since it is relevant to the death penalty, I am bringing it up here in this video with regard to the 8th Amendment. Now, a few years later, another case came out of Georgia and reached the Supreme Court, and it was determined that its reformed procedures, the state of Georgia had reformed its procedures to be more fair, so the death penalty was being imposed more fairly. So the Supreme Court then again allowed capital punishment, and to this day, it is a constitutional punishment. Now, that's not all there is to the issue, because there's still a question of, even though the death penalty is in general constitutional, there's still questions about specifically to whom it can be applied, when it can be applied, how it can be applied. This case, 2002, Atkins versus Virginia, the question was, what about the mental health of the criminal? Or the mental development of the criminal. Now, I'm sorry to use the phrase mentally retarded in this slide. That was the phrase being used back then, and that's what shows up in the Supreme Court's decision itself. Basically, the defendant in this case, the convicted person in this case had such a low IQ, the Supreme Court said in that situation, imposition of the death penalty did violate the cruel and unusual clause of the 8th Amendment, because the person couldn't tell right from wrong. There would be no understanding of the relationship between the crime and the punishment. The punishment could not serve as a deterrent. That means the possibility of being punished wouldn't have had any effect on the person committing the crime. So in that case, the Supreme Court said that states can states get to define the specific level of IQ or development, but some people fall in a category where the death penalty being applied would be unconstitutional. The next case, 2005 Roper case, it was decided that for criminals who commit the crime under the age of 18 as a minor, it would be unconstitutional to impose the death penalty on them as well. In a 2008 case, the issue was the method of execution itself. Now, I think most states have the death penalty, and the federal government does have the death penalty, and I think the most common method of execution is lethal injection. It's a combination of drugs that eventually result in the death of the inmate. The question here was: is that method of executing someone itself cruel or unusual? And the Supreme Court's decision in 2008 is that it is not. Now, you probably read in the history books or seen the movies or whatever. Other methods like the gas chamber and the electric chair, and of course there's always a good old firing squad. Typically those methods aren't used anymore, although you could probably find some that have been used in the last 20 or 30 years. But this case was specifically about the lethal injection method, which was seen by most people as at least as somewhat more humane. And then finally, kind of an interesting way to wrap this up. A court case from very recently, 2019. Finally, it is the last example of incorporation that I can give you. Part of the 8th Amendment refers to to not imposing excessive fines, whatever excessive is. And in this case, the state of Indiana was found to have imposed an excessive fine on an individual. And by this case, the Supreme Court officially incorporated that phrase from the 8th Amendment. So exciting. Now, the 8th Amendment isn't very long, but it's got a lot of stuff in it. It provides both pre-trial and post-trial protections. The pre-trial protection is the prohibition against excessive bail, and the rest of the amendment, the prohibition of excessive fines and the prohibition of cruel and unusual punishment are post-trial protections. The 8th Amendment is most famous for that last phrase, cruel and unusual punishment. And it comes up all the time when it comes to capital punishment or the death penalty. Clearly, everyone agrees that this would prohibit torture, but various other details about the act of putting someone to death for their crimes has been a long-standing controversy in this country, and the Supreme Court has recently shown some flexibility and some what you might call sensitivity to how public opinion and sometimes international opinion have been evolving on the issue. This has been the last of 4 videos devoted to the concept of due process. Hope you found them enjoyable and informative. Don't get caught up in all the cases. Most of them have been mentioned in these videos just to give you a more detailed understanding of some of the issues that come up when you're talking about due process. There are a handful that are required by the Supreme Court, so focus your studying efforts on them. See you in the next video.